We have more for your ears only. I'm Eddie Robinson.
I'm David Alpern with this quote from the news. This regime all along has believed it can simply kill its way out of this. That was Middle East advisor Monica Yacoubian of the Stimson Center in Washington on the conflict in Syria after UN monitors took fire en route to the fourth reported government-backed massacre in 2 weeks, with little international appetite for military intervention. Now this.
It's surprising that the jury has so many persons affiliated with Penn State. Part of it, of course, relates to the fact that they're in a part of the country where Penn State is the number one economic driver. It's the number one employer. It probably would have been difficult to pick a jury with no ties or few ties to Penn State.
12 jurors and 4 alternates were chosen last week in the Jerry Sandusky child sex abuse case that sent shockwaves through the Penn State community and led to the ouster of its beloved Hall of Fame football coach, Joe Paterno. Among the 16 selected, 10 have some tie, direct or indirect, to Penn State, including several jurors with connections to key witnesses. But that's only one controversial development the case has seen, even before lawyers this week began opening arguments.
In a decision that raised more than a few eyebrows, trial judge John M. Cleland announced that those jurors will not be sequestered or watched by law enforcement during the multi-week trial. Similarly controversial was his ruling that the alleged child abuse victims would have to give their real identities to testify. And prosecutors recently had to amend charges against Sandusky to acknowledge that a key shower room incident in the case took place a year earlier than the principal witness previously indicated, raising potentially serious questions about his credibility. To consider these and related issues for Your Ears Only, we're joined by veteran criminal attorney and TV legal commentator Janet Johnson of Jacksonville, Florida. Welcome to our program.
Thanks for having me.
Remind us of the major charges against Sandusky and the maximum sentence.
Well, he has, 52 charges that he's facing. So I was counting for each count. 11 of them are first-degree felonies, which carry 20 years each. So arguably, if the judge was going to make those consecutive, just on 11 counts, he's looking at 220 years. So, quite frankly, it's off the charts, the amount of time he could be doing. But there's, first-degree felonies all the way down to misdemeanors, each of them carrying from 20 years down to 5 years in prison, and the judge can keep stacking these on top of each other. So he would be guaranteed to die in prison if he's convicted on 1 or 2 of these counts.
On balance, do you think the Penn State ties of so many jurors will play a role in their verdict or constitute the basis of an appeal?
I keep going back and forth about whether it hurts him or helps him. Clearly, he was protected by the community in one way or another. So I think in the end, it helps him to have that many Penn State, affiliated people on the jury. What I think is the more significant thing and sort of worse for him as a defense attorney is that there are more women than men. And I think this is a case where I would, the Penn State faithful, that's fine, but women, I think, are going to be really hard on him. And this would be a jury where I would personally pick more men than women.
Do you think avoiding jury sequestration will help either side much? Would you have argued for it?
You don't want the jurors to be rushed in any way, and if they're sequestered, they tend to want to get it over with sooner, which I think is not good for the defense. I think if they were going to be tainted by media coverage, it would have already happened. This case has been playing out for the past year in the media. Anyone who hasn't heard these details already, I think, in Penn State land, I think that would be unavoidable to begin with. So I would be okay with them not being sequestered if I were the defense.
What's your reaction to denial of the victim's request to use pseudonyms in court?
As a defense attorney, we're always put in the position where we're appearing to be anti-victim. But quite frankly, I think you should have to be named if you're accusing someone of something this serious, especially so long after the fact, so long after it happened. It's a little difficult to hide behind an anonymity. If you're going to make this man potentially spend the rest of his life in prison, I think it's important that people know who it is who's accusing him.
These charges go back so many years with little or no forensic evidence, and the victims' ages ranging from 10 to 15 years old when the alleged abuse occurred. How rough can defense lawyers be on them to recall clearly what happened to them so many years ago and at such a young age?
Well, that's, for the defense, that's kind of great fodder to say. There's going to be inconsistencies because nobody's memory gets better 10 years after the fact. And it's also, an argument, other than Mr. McQuarrie, who saw what he claims that he saw, he's an eyewitness, not a victim, just an eyewitness. it's all going to be their word against Mr. Sandusky's word. And, the argument's going to be, you heard about other people coming forward, you got on the bandwagon, you have a civil lawsuit against Penn State. I'm sure that that's the fact with many, many of these victims. So the motivation is going to be questioned, and if it happened, why didn't you speak up sooner? It's a tough line to cross-examine when you're the defense attorney, but it's necessary. They're going to have to go after them.
What weight do you think the jurors will give what we hear may be creepy love letters Sandusky allegedly wrote to some of the boys involved?
Yeah, I mean, that was, like this bombshell. Apparently the prosecution thinks they're going to give a lot of weight. They're going to open with that. Apparently that's their first piece of evidence. It's been their defense from the beginning. Look, he showered with boys. He horsed around with boys. Is this, weird? Yeah, it's probably weird. Is it criminal? It's not criminal. And I think that's been, even that interview he gave that's now infamous, it's famous for him when he said, are you sexually attracted to boys? And he sort of hesitated, and he said, sexually attracted. It's going to come out that he likes hanging out with boys. Michael Jackson, I think, ran the same defense. He would hang out and share a bed with boys, but he didn't molest them. He didn't attack them.
For our last few minutes, let's switch gears and get your thoughts about George Zimmerman and Florida's Trayvon Martin case. A judge sent him back to jail last week after learning Zimmerman and his wife lied about their finances to get a lower bail in April. Some people think he'd be safer in jail, but you see legal dangers there, tapes and snitches.
Well, I know these prosecutors. They're actually, the special prosecutors are from Jacksonville, and they're going down to Sanford to prosecute this case, but they're people I've practiced opposite for 18 years. And Bernie Della Rianda and Angela Corey specialize in homicides, and they have a knack for getting jailhouse snitches. And to me, it's inevitable that there will be somebody that is, I don't want to say planted, but someone who's in the jail who they will have contact with who will say, he told me X, Y, and Z, and somehow statements will come out that will hurt him. I mean, even just the week he's been sitting there, I suspect that's happened. I've had people in isolation who are in solitary confinement who somehow they managed to get people who my client supposedly confessed to. So to me, it's a time bomb with him sitting there.
Does deception on the bail affect his credibility about the shooting and his possible stand-your-ground defense?
Yeah, and I thought this from day one. Even before this happened, there was another case in Florida called Marissa Alexander. She's the name of the defendant, and she had a stand-your-ground defense. She bonded out, and I think about 4 months after she bonded out, she went to the victim's home and got arrested for a battery on him. She would have won stand-your-ground. I mean, it's been sort of a public outrage that she didn't, but the judge said, I don't find you credible. You say you're afraid of this person, and this is how you behaved in conjunction with the bond. The judge has already said, I don't find you credible now. And that's a huge problem because stand your ground in Florida is a pre-trial motion that the judge hears, and he weighs your credibility in determining whether to grant you immunity and dismiss the charges. And he's already saying, right now, you're not credible. You can rehabilitate yourself by explaining to me why the money was basically hidden and we weren't told about it. But right now, he's has a mark against him, which could mean the difference between having it thrown out or going to trial.
Janet Johnson is a veteran criminal defense lawyer and TV commentator in Jacksonville, Florida.
Quote from the news, what is coming next is a generation whose ideological positions are more virulent and who are less likely to be restraining their actions. That was a former Australian counterterrorism analyst after yet another al-Qaeda deputy leader was killed by a U.S. drone strike in Pakistan.
Next, bringing American capitalism back to its roots. For your ears only.